Hello, and welcome to CCK Live. My name is Christine Clemens, and I'm a managing attorney at Chisholm, and Kilpatrick. And in this video, I will be breaking down the details of a recent CCK case. In 2019, the veteran's surviving spouse reached out to CCK for assistance with a claim for an earlier effective date of DIC, Dependency and Indemnity Compensation benefits, for service connection of the veteran's cause of death. This was pending in an appeal before the Board of Veterans' Appeals when this surviving spouse contacted us. And a little bit about the veteran's service. He had served in the Army from 1966 to 1968, including at Korat and Utapao Air Force bases in Thailand, before passing away due to multiple myeloma in 1996. Although his widow had applied for service connection for the cause of death that same year, in 1996, she was denied benefits. Years later, she reopened the claim, and VA finally conceded the veteran's exposure to herbicides in Thailand. And ultimately, she was successful in establishing service connection for the cause of death in 2015. But because she had submitted service department records, she felt she should be entitled to an earlier effective date. And so she appealed the effective date that VA had assigned to her of 2015. And when she did that, VA discontinued her benefits entirely. So fast forward to the surviving spouse reaching out to us. When CCK took the case, we thought that this would be a fairly clear-cut application of law to facts on this earlier effective date argument. But it turned out to be a little bit more complicated. After reviewing the facts of the case, we determined that there were two separate issues: the entitlement to an earlier effective date and the severance of her benefits. The severance of benefits was further complicated by the fact that, due to some confusion in the case, she didn't appeal VA's finalization of that severance. And so she was no longer receiving DIC benefits, but it also wasn't on appeal. Unfortunately, we were past the 1-year point to appeal that decision. So we were beyond the appeal period of that decision. So as it turned out, only the earlier effective date issue was on appeal, but it was seeking an earlier effective date for benefits that VA had determined she was not entitled to anymore. And we steadfastly believed that VA was wrong in that determination. So we decided that the best likely outcome would be for us to first work to get that benefit reestablished. We also thought that VA's action was pretty egregiously wrong, so we wanted to try to get her benefits reinstated and to maximize the amount that she was paid, and to get her kind of reimbursed for that mistake that VA had made. So first, a little bit on what VA did. In order to sever her benefits, VA had found that there was a clear and unmistakable error in its own decision to grant her benefits, stating that a statement from a spouse cannot be considered sufficient verification of perimeter duty. So she had given a statement because her husband was deceased. There was other evidence in the file as well, including maps of the base. And again, there was an impossibility of getting that statement from him. So this policy that VA had to require a statement from the veteran, we felt was not really necessary. And they even felt that it wasn't necessary the first time around. So something to be aware of is that clear and unmistakable error, which is the standard that VA had to establish. It's a rare kind of error. Essentially, the standard is that it's a kind of error that like-minded people would not disagree as to the error. In other words, it's undebatable. So the issue of requiring a statement from the veteran as part of their policy, we said was really irrelevant, because VA had essentially conceded that it was irrelevant when they conceded his exposure, even without his statement. And that's because they conceded it because there was other credible evidence of exposure. VA had correctly weighed the evidence, we thought, the first time to concede his exposure in granting the benefit. And therefore, we argued that in order to find clear and unmistakable error with their own decision that would be required to sever her benefits, they would have had to establish by undebatable evidence that he was not exposed to herbicides. They couldn't meet that onerous standard to establish Q that was required before they could sever her benefits. And because of that, their failure to establish that the legal standard to sever had been met before they terminated benefits was itself clear and unmistakable error. So essentially, we were having to argue through layers upon layers of clear and unmistakable error. How their finding that there was clear and unmistakable error was not accurate, and that in fact it was clear and unmistakable error because they hadn't met the legal standard required to sever her benefits. So what happened? The regional office denied our motion to revise their decision based on clear and unmistakable error. And we did have to appeal that decision to the Board of Veterans' Appeals, but ultimately CCK was successful in convincing the board to restore our client's benefits to the date of severance in 2018. So her DIC benefits were reestablished, and we got them to reinstate them back to the date of the severance, the improper severance. We also thought all along that the best way to get her the earlier effective date, which is why she came to us in the first place for those DIC benefits, was to reestablish those benefits. So once we had done that, we could kind of get going on our earlier effective date arguments. So then in June of 2022, CCK was successful in getting the board to grant an earlier effective date for a service connection for the cause of the veteran's death back to 1996. And this was based on a regulation 3.156C. Essentially what that regulation says is that anytime after VA issues a decision on a claim, if it receives or associates with the claims file relevant official service department records that existed and had not been associated with the claims file when VA first decided the claim, VA will reconsider the claim. And that was a way to get that earlier date. There were service department records that had entered the file. They were part of what helped VA establish his exposure to herbicides in Thailand. And because they were relevant to that determination, that they should have been used to essentially go back to her original claim for benefits. And we were successful in that. So this win resulted in decades of back pay for our client. And she was very happy in the end with the result here. So a few things just in closing is something to keep in mind. I've talked about clear and unmistakable error here today. We have videos on clear and unmistakable error as well. There's often error in VA cases and the adjudication of cases, but it's rare that that error rises to the legal standard required to establish clear and unmistakable error. That's why it can be beneficial to work with an accredited representative, an accredited agent or attorney, or VSO, who understands the nuances. So thank you for watching. As always, if you need help with your VA claim or appeal, don't hesitate to reach out to see how our team of accredited representatives may be able to assist. More CCK case win summaries can be found on our website, so be sure to check those out and check out our other videos and follow us on social. Thanks and have a great day.